A man leaves his donkey on the side of a dirt road in England. The animal's forefeet are fettered. It is dusk. Soon, a heavy wagon will come down the hill too fast, and a collision will occur. Why does a dead donkey on a road in 1842 still governs how we assign blame today? There is a running joke in the academy. An economist who picks up a law journal will understand almost all of it, but a lawyer who picks up an economics journal will understand none of it. The lawyer sees rules, statutes, and morality. The economist sees something else entirely. We are going to examine this legal framework the way an economist reads a market. Every doctrine in the textbook, precedent, the court pyramid, the burden of proof, is an economic technology. A legal system is not a museum of historical rules. It is an active, self-reprogramming incentive machine that allocates risk and forces information. Let's open the casing and look at the gears. Modern law operates on two dominant operating systems. When the French revolutionaries executed their king, they abolished his courts and commissioned a top-down rationalist blueprint, the Code Napoleon. That civil law tradition contrasts sharply with the English common law, which grew organically from judges resolving highly specific, localized disputes. This procedural divide represents a choice between two distinct models of information cost allocation. In the common law's adversarial process, the heavy cost of discovering and presenting facts is placed entirely on the private parties. In the civil law's inquisitorial process, the state-appointed judge takes an active role in ferreting out the truth, shifting the marginal cost of information production onto the public ledger. The United States inherited the common law and structured it into a strict three-tier hierarchy: trial courts at the base, intermediate appellate courts in the middle, and a single Supreme Court at the top. The trial courts act as a massive industrial filter. They absorb an enormous volume of highly specific, fact-intensive disputes. Juries weigh the credibility of witnesses, and judges apply existing rules to local chaos. But as you move up the pyramid, the facts freeze. Appellate courts do not hear new evidence. By the time a case reaches the apex, the court commands absolute discretionary review. They reject roughly 90% of the petitions they receive, reserving their capital strictly for cases where the rules themselves are fractured or contradictory. The court hierarchy is a deliberately engineered error correction architecture. It isolates the high-volume noise of factual disputes at the bottom to protect the severely scarce, highly valuable capital of supreme judicial rulemaking at the top. Within this hierarchy, precedent operates as an economic commitment device. When a court binds itself to past decisions, it dramatically lowers the variance of expected legal outcomes for future litigants. This predictability has a mathematical function. It manufactures settlement. This equation models the settlement range. A plaintiff and a defendant will settle their dispute out of court as long as the plaintiff's expected judgment, minus their litigation costs, is less than or equal to the defendant's expected judgment plus their litigation costs. Precedent forces the plaintiff's probability of winning and the defendant's probability of losing to converge. By shrinking the gap in their expectations, the law mathematically traps both to resolve uncertainty. It uses burdens of proof. Evidentiary burdens are mathematical decision thresholds. They are calibrated to minimize the asymmetric costs of false positives, or type 1 errors, versus false negatives, type 2 errors. Grave. In criminal law, a false positive results in the wrongful imprisonment of an innocent person. Because that type 1 error cost is extraordinarily high, the math dictates that the required probability for conviction must slide far to the right. We call this threshold beyond a reasonable doubt. Contrast this with a civil contract dispute. If the court accidentally forces the wrong private party to pay damages, the social cost of the error is relatively symmetrical. Therefore, the decision threshold centers perfectly, requiring only a preponderance of the evidence. 51% believability wins the trial. Static legal rules are highly calibrated mathematical thresholds designed to force private settlement and minimize total social friction. The static architecture is elegant, but economies are not static. How does this mechanism dynamically rewrite its code when encountering a novel economic problem? In 1809, in the case of Butterfield v. Forrester, a man was repairing his house and left a heavy wooden pole obstructing a public road. At 8 o'clock in the evening, the plaintiff rode his horse violently down the road, failed to see the pole, struck it, and was injured. The defendant who left the pole was clearly negligent, but the court ruled that the plaintiff was also negligent for riding recklessly. Lord Ellenborough held that the plaintiff's contributory negligence acted as a complete bar to his financial recovery. The injured writer received nothing. To understand why this harsh rule is economically rational, we apply the Hand formula. The law seeks to assign liability to force precaution whenever the burden of taking that precaution is less than the probability of an accident multiplied by the magnitude of the loss. In Butterfield, the accident required 2 negligent acts to occur. By penalizing the reckless rider, the court targets the party with the lowest marginal burden of precaution at the exact moment of the hazard. The rider simply needed to slow down. The Butterfield ruling effectively programmed the legal machine to solve for single-actor optimal precaution, establishing a ruthless economic incentive for unilateral safety. But the code had a bug. The Butterfield rule fails to produce efficient outcomes when 2 parties act negligently in a time-delayed sequence. 33 years later, we arrive at the case of Davies v. Mann. The plaintiff illegally leaves his fettered donkey grazing on the highway. The defendant drives a heavy wagon down a slight descent at a smartish pace and crushes the animal. Under the strict logic of Butterfield, the negligent donkey owner should be barred from recovery and walk away empty-handed. But the judges recognized the resulting inefficiency. They invented a doctrinal patch, the last clear chance rule. The economic goal here is bilateral care. The law must minimize the joint social costs of precaution and expected damage when multiple parties interact across time. The last clear chance doctrine correctly shifts absolute liability to the actor with the lowest marginal cost of avoidance at the final moment before impact. The wagon driver had time to swerve. The fettered donkey did not. This raises a theoretical cliffhanger. What happens if the defendant wanted to take that last clear chance, but couldn't because of their own earlier negligence? The system processed that query in 1916. In British Columbia Electric Rail v. Loach, a man negligently drove his wagon onto train tracks and stalled. An oncoming train engineer saw him and applied the brakes. The brakes, which the railroad had negligently failed to maintain, gave out. The train killed the man. The railroad argued they did not have the last clear chance because their brakes were broken. The court closed the loophole. They ruled the railroad liable because they would have had the final chance, but for their failure to maintain equipment. This sequence, from a wooden pole to a fettered donkey to a speeding train, is a live demonstration of the common law debugging its own code to optimize for complex sequential interactions. Did the judges across these 3 centuries actually understand the constrained optimization math they were enacting? No. Read their opinions. They were consciously arguing about natural law, proximate cause, and moral blameworthiness. They never mention economic efficiency. This brings us to a highly contested but incredibly powerful framework in law and economics, the common law efficiency hypothesis. It dictates that the system drifts toward economic efficiency, regardless of the conscious intent of its human operators. The selection mechanism is driven by deadweight loss. Inefficient rules create heavy friction in the market, which raises the financial stakes of disputes governed by those rules. Higher deadweight loss destroys the settlement range we established earlier. Because the parties cannot find a mutually beneficial clearing price to avoid court, inefficient rules are relentlessly forced into costly appellate litigation, while efficient rules are settled quietly and leave the docket. The appellate courts act as an evolutionary sieve. Bad rules are subjected to the intense fire of continuous litigation until they randomly mutate into economically efficient equilibria. Once a rule becomes efficient, the litigation rate drops and the rule survives. The beauty of this architecture is that it requires no omniscient planner. The machine optimizes without a designer. Which brings us back to our opening question. Why does a dead donkey in 1842 govern modern law? It remains foundational because it was the precise moment the legal algorithm successfully solved the sequential bilateral care problem. The judges thought they were dispensing rural justice. What they actually built was the ultimate self-reprogramming economic engine.